Our next TED Talk is going to be from Amar Sarwal. He's the Vice President and Chief Legal Strategist for the Association of Corporate Counsel. And just a quick blurb there on the ACC, for those that may not be very familiar. ACC is dubbed as the voice of the in-house bar. So obviously they work a lot with the client side of a lot of the folks that we serve. And Amar's job is actually really cool. He gets to be the one that works with the CLOs and executives, both a lot on the client side, but also on the law firm side, in trying to define ways and strategies that we can come together and create more value for each other and work together in more collaborative ways. So I had the luck, I guess, of co-presenting on a webinar with Amar a couple months ago. Actually, it was almost about a year ago, I guess now, right? It's been a while. And Justin was on there with me, and we came off that call. I had never met Amar before, and I'm like, God, this guy's awesome. This is great. So when we were starting to come up with ideas on people that we wanted to invite and see if they participate, I shot Amar an email, and he was like, oh, he was very enthusiastic about it. So it's really great to have him here and his contributions. And so with that, I'll introduce Amar Sarwal. He's going to be speaking on the future of legal services and in-house perspective.
Thank you, Keith. I think Toby should have just dropped the mic. He basically said everything I was going to say. So it'll be 18 minutes of blah, blah. You can ignore that till the question and answer session, and we can return to Toby's stuff. As Keith mentioned, I'm the Vice President and Chief Legal Strategist of the Association of Corporate Counsel. I'm really excited to be here. I came here 2 years ago for the inaugural P3, and to see it grow like this is really inspiring. We're launching some of our own stuff that's analogous, and I'll mention that in a second. But it's just amazing to see the growth of this, and Toby's absolutely right. You're the ones that are driving legal change in the legal market. We want to collaborate with you. I'll rant and ramble a little bit up here, but at the end of the day, I'll try to return to this, that we're here to work with you. Our members want, particularly our legal operations professionals, want to work with you. They want to learn to speak the same language and drive the same kind of change you want to drive. So there's a lot of synergies between your industry, your role, and the roles that we have in the in-house bar. Before I talk a little bit about what we do at ACC, I just want to thank P3, Keith and Purvi. I want to thank all of you for being here. I also want to thank all the sponsors and vendors. That's also what's very exciting, to see these third-party providers that are joining this market, joining this effort to change, being some of these early adopters and these innovators that Toby talked about. Anyways, Association of Corporate Counsel, we're worldwide. We're in 85 countries. Our members work for over 10,000 companies, law departments, and we have about 37,000 members. Well, about 40,000 in about a few weeks as we're joining with the Australian Corporate Lawyers Association. So that perspective, I'm just lucky and blessed to be in my role, get to be able to see a lot of developments that are out there. I have a front row seat to what's happening in the legal services industry. My team, it's not me. Keith mentioned that Amar works with these CLOs. I have a great team that works on these issues. Some of them work on advocacy on behalf of the in-house bar, advancing the unique perspective that we share, that voice of the in-house bar that Keith talked about. We're always looking for opportunities to talk about privilege and right to practice, the freedom of mobility of lawyers. So if you see them in your law firms, we're happy to collaborate with you. Our team also works on engaging general counsel as general counsel in their roles as trusted advisors, business strategists, leaders of the law department function, helping them to promote talent and develop talent. We have a succession planning initiative where we train the next generation of general counsel. And finally, my team works on the ACC Value Challenge. I'm sure all of you have heard of it. In 2008, ACC launched this challenge. It was an effort to reduce the reliance on the billable hour, to use appropriate fee arrangements. We heard that from one of our members. Instead of saying alternative fee arrangements, we now say appropriate fee arrangements. To increase the use of project management, process improvement, root cause analysis, all basic common sense business principles, to incorporate those, though, into the practice of law. That effort, we believe, is very successful. We haven't reached the tipping point, but we believe that tipping point is in sight. Last week, we had our first conference for our legal operations professionals. This is a new role within law departments. This is a role where, at the behest of the general counsel, they manage budgets, staffing, to deal with outside counsel management issues, analytics, et cetera. You may see some similarities and synergies with what you do. It's a tremendously successful conference that had almost the same kind of programming that you have here, which, by the way, I just am blown away by. The programming you guys are going to have over the next 2 days. It's just a real treat, a real intellectual feast. So in any event, turning to the topic that I have today, which is the future of legal services. It's a very capacious topic, can basically cover anything, and I only had maybe 13 or 14 minutes left. So basically, I thought we'd do a SWOT analysis, using a strategic tool like strengths, weaknesses, opportunities, and threats, and analyze the legal industry. Maybe I thought we'd better to turn it around. Start with threats and move on to strengths. The idea being that this is a hopeful message. I know there's a lot of doomsayers out there. There's a lot of stuff in the legal press that this, that is the end of big law, or it's the end of our traditional practice of law, which it probably is the end of traditional practice of law, but it's not all doom. I think there's a lot of hope out there. We actually think we're entering a golden age of providing legal services for our clients. They need us more than ever. So let's start with threats. The leading threat that our members face is this idea of where were the lawyers? We've been hearing it ever since Enron, certainly most recently in Penn State and with General Motors. There's a lot of examples in between. But this idea that the lawyers didn't do enough to either detect or remedy misconduct. They didn't step up and say, you shouldn't do this, or act as adequate gatekeepers. Our members hear this over and over, and our stakeholders now are starting to lose faith in the legal profession as a profession of integrity, a profession of independence, and that's problematic for all of us in this room and for our members. Whatever we can do to displace that perception, the better. But unfortunately, we act in that situation against an age of transparency. Right now, we're in a situation where our stakeholders want to know everything. Ever since Watergate, where the cover-up was worse than the crime, our stakeholders are asking, what did you do to investigate this misconduct within the company, and how adequate was that investigation? And if we don't disclose the privileged communications related to that investigation, then they don't believe us. But that's problematic. You can imagine, as your law firms well know, that it's hard to have the safe space to encourage candid communication if you don't have confidentiality associated with it. And so that leads to perhaps fewer clients going to lawyers, at least at the margins, about the issues that confront them. And that's problematic for the wider civil society. It does not promote compliance with the law. Well, and what else have stakeholders done? The government, other professional societies, they've created a new function, the compliance function within companies. And it's in a sense, at least for those companies that have had to separate because of government pressure, separate the compliance function from the legal function, it's been an end run around lawyers. The idea of, I've heard a government lawyer said on a panel with me that lawyers are advocates. We don't feel that they possess the same level of integrity or independence. And that was really offensive. That's what were lawyers called to do? Why do they have professional ethics rules, et cetera, et cetera? But it's an end run around what lawyers can provide. It makes us almost bystanders in our own profession. And we're bystanders against an era of limited resources. You've all heard the idea of doing more with less. It animates the value challenge, and it's been around for a while now, even prior to the last financial crisis. And that's not going away. That's a secular shift in the legal industry. We hear it over and over from our general counsel members. We're going to have to find efficiencies in whatever we do, because it's not cyclically going to go back to what we had 10 years ago, 20 or 30 years ago. We're going to be in a secular shift for a long time. So those are some of the threats out there. It's the back of the envelope strategic analysis. I'm sure there are other threats that your greater insight can deliver. Moving on to opportunities. A clear one, an opportunity that our own clients, our corporate clients have found, is globalization. They've been able to find new emerging markets for the unique value proposition they bring with their products and services. The same thing can happen for your law firms. I know there are barriers to entry in those legal markets, but we at ACC and others are working on reducing those barriers. That's going to take time, but those are going to be new opportunities to sell what you do. There's technology, as Toby mentioned about Watson. Watson shouldn't be something that scares you. Instead, actually, your firms possess more knowledge about how the law works, what the legal requirements are, than anyone else out there. So you can incorporate that legal knowledge, that insight, into Watson, into companies like Neotologic, which create decision engines. I know some of the firms in the audience have used Neotologic. It's another way of delivering your legal services. And that actually increases the margins. It may take a change in your business model. You may have to focus a little bit less on leverage, maybe a different kind of business model that focuses on the technological inputs as well. That requires change, no doubt. But that's a technological change. Globalization has led to more regulations, more regulators. Our members are deeply frustrated. Our clients are deeply frustrated with all of the laws that they have to comply with. A few years ago, we did an analysis of all the privacy regimes out there, and we found at least 37 of them, and many of them were orthogonal with each other. It was very difficult to figure out how you comply with them. And then you have the overlay of parallel regulators. Regulators that sometimes don't talk with each other, or even when they do talk to each other, they piggyback on each other, and they provide, they provide multiple duplicative penalties. Now, I put this in the opportunity section. You wonder why? Well, that's job security for all of you, and job security for our members, right? The more regulations and regulators that are out there, the better for all of us. But that doesn't mean you can't talk about what happened yesterday. You can't send, when our members get 30 briefers a day about all the different, and then the most recent Supreme Court case, a case that was decided yesterday, had a bunch of briefers out immediately. You got to talk to them about what's happening around the corner. That's what they really value. So that's yet another opportunity out there. And then the final one I want to talk about is the advent of all of these other players in our market. First, there's the third-party providers. I see someone from Novus Law here. The folks from Elevate that we've worked very closely with at ACC. These are partners that you can work with closely in your firms, and that's wonderful. But there are other folks, like the Big Four, the HR consulting practices, particularly HR consulting practices, some of which have said that most problems are people problems, and we can solve those people problems, and you'll have a few legal issues that'll just be remainder things that a law firm can help you with, sharply reducing the margin of the firms in this room. Well, we could turn that around, because our corporations need to rethink their organizational design. The environment we're in right now, the old-fashioned corporation doesn't make as much sense. We can help them because at the core of organizational design are rules. And who better to figure out how to develop rules, articulate rules, create the enforcement of those rules, et cetera, than people who know how laws work. So we can turn it around and say that legal professionals should be driving those changes within corporations, not the Big Four, not the HR consultants, not all the others. And those are some of the opportunities that are out there. But unfortunately, against those opportunities and those threats are a bunch of weaknesses of our profession. And Toby's gone through a lot of them, but I'll just start with a few of them. One is our deeply inappropriate legal education system. We have a legal education system that has been poor fit for our industry for many, many years, long before the financial crisis. It's only been exposed in the last few years to the rest of the world. There's a lot of things we can say that are problematic with the law school system, but I'll say the basic one that we care most about is that the law school system today produces issue spotters. It does not produce solution finders. And until it produces lawyers that are solution oriented, our members, and I'm sure you know this, many of them will not pay for first and second year law firm associates and pay those fees because they're not trained for the world we live in. And I know there are law firms in this room, and I know that there are in-house departments that are working closely, teaching, developing new curricula for law schools. That will be a big change. But another very big change will be learning what it means to be a good lawyer. That's one of our weaknesses in our profession is we really don't have a good sense of what it means to be a good lawyer and to deliver a good legal work product. There's reputation. As Toby pointed out, we look backwards and we look at where you went to law school. Whether you were in law review, who you clerked for, who you might have worked for in the government 30 years ago. These are not indicia of quality. So clients are using reputational metrics that are just not correct and not helping to drive change. Fortunately, there are a number of efforts out there to develop quality and performance metrics, and so we think that will change things when we have a better sense of the process, not just the outcomes. Did you win the trial, et cetera, or did you get a good settlement, but did you actually do a good job on each of the units of a trial or the units of a deal, et cetera. Another weakness of our profession is the fact that we have an anti-competitive regulatory regime. We have state bar after state bar, no offense to the Utah State Bar, to Toby's old bar, but the fact is that our state bars have protected us in a guild-like way, in a monopolistic sort of way, and that has caused people to be more resistant to change than they otherwise would have been. We would have adopted all these common sense business practices decades ago, perhaps when Toby first started, but we haven't because not that long ago, 20 years ago, but we would have adopted them a long time ago. And we at ACC are considering challenging those frontally because we think that the alternative business structures approach that's in London, if you guys go there next year, the alternative business structures approach that's there might be a better way of approaching this. At least at the very least, we think for sophisticated clients, our clients, that we should get something of an opt-out from the unauthorized practice of law rules. We should be able to hire the lawyer of choice, whether they're barred in that particular jurisdiction or not. Finally, because of that regulatory regime, we have a partnership structure for law firms. And that partnership structure makes it really hard to develop a coherent value proposition. It makes it very difficult to develop a coherent brand. The compensation systems, the talent promotion systems, they could be much stronger, perhaps, in the absence of a partnership system. So I really feel for all of you guys that you're working almost like Sisyphus against the tide. I'm mixing metaphors, but you're working against the structure of how your businesses operate when you have a book of business that determines whether the new partner will come in, maybe as opposed to client service or meeting client expectations. So those are the threats, opportunities, and weaknesses. But actually, as a bar, I want to leave with a hopeful message because we actually have a lot of strengths. Table stakes for entering the legal services industry is that you're smart and thoughtful. Everyone in this room, all of the partners that you work with, the in-house lawyers, you have to be on the higher end of the IQ scale. So you have that. On the particular matters, you have to be very strategic. The strategic advice you give on a piece of litigation or mergers and acquisitions, et cetera, you're being strategic with your client. We may not have transferred that to the rest of the industry, but on particular matters, we're more strategic than others. We're also more understanding of change than others. I think, while we're not at the point where we'd like to be on that crossing the chasm chart, you look at other professional services industries, they're actually not that far. They're not that much better at pricing. Some of them are actually worse at pricing than we are. So we've got enough folks, particularly those in this room, that are understanding of change. We also have access to tremendous client data. Now, obviously, you have pricing data. I urge you to use that data and mine it to figure out best fee arrangements for our clients. But we have other data. You have the data from the actual matters themselves. And that data can help the client proactively address those issues within their companies, identify which employees are the cause or source of issues. It can also help you re-engineer the legal services that you provide. Very few industries have the kind of data we have, and it's low-hanging fruit because we haven't used very much of it to date. And then finally, I will say that biggest strength is represented by the folks in this room. We have, historically, we've had bar associations, corporate counsel associations, inns of court. We've had lots of opportunities to work together, to share with each other, to benchmark with each other. The more we do that, a rising tide, right, lifts all boats. The same thing will happen here. So I guess I'll just close with that I'm very excited to be here. I'm very excited to be here for an education session that we're going to have this afternoon about the value challenge. We want to work with P3. We want to work with everyone in this room and your law firms to drive change in the legal services industry. Look forward to your thoughts.
So appreciate Amar's work and Toby's work. I'd like to invite Toby back up here. Obviously, in the spirit of interaction and collaboration, we'll open up to Q&A, and I don't know, anybody can start from there. Oh yeah, there's another one. That's right. Anyone?
Okay, question. What tool to put in the grades? That we're now the flashy thingy. That's Umbria from ProsperoWare. But there are a lot of other tools on the market. That's the one we happen to go with. But I'd say push that grade in their face every day. We'll start here and then we'll work our way around. Question.
So, what were the big takeaways from the operations sessions last week? First, it's definitely a very engaged group, much like the folks in this room. We had a general counsel panel that started the conversation because the legal operations professionals role, I think is probably the analog here, isn't as well defined. And so there's a real need to define that role for companies, and particularly as new GCs come in. So these two general counsel, Mike Dillon of Adobe and Cam Finley of ADM here in town, they both spoke about how important that particular role was for them. They talked about how they've engaged in convergence. At the same time, though, interestingly enough, and I pressed them a little bit on this, but they talked about disaggregation, and you wonder about how convergence and disaggregation work together. But They had a very cute answer because they're general counsel. We talked about the wide range of issues that were talked about here. I think the biggest takeaway for us as ACC is we had a number of special interest groups that we formed on metrics, on external resource management, internal resource management, because they feel very strongly about developing metrics for their, or mechanisms for figuring out how to develop their own talent. We also had other benchmarking interest groups. I'm trying to think of but these interest groups that we've created, we intend to reach out to the outside bar and to others to be able to collaborate. We also have an effort, two or three that you guys should know about. One is to look at outside counsel billing guidelines. Try to, because I'm sure you guys have to deal with this all the time.
Thank you.
So, because it's unfortunate, because I didn't say this to you, but I do say it to our general counsel members. They're the problem. A large portion of them are resistant to change themselves. And so your law firms, a lot of them have actually thought very hard about how to develop appropriate fee arrangements with your help, to develop, use project managers. For instance, our billing guidelines, some of them don't even pay for project managers, right? They say, we won't pay for project management. And they're afraid you're going to use that to cover up administrative timekeepers. They're wrong. They need to encourage this development. Our clients might say our members might say an appropriate fee arrangement actually is a discount. That is not right. We have to, a value-based fee arrangement, an appropriate fee arrangement, a discount is not one of those. And if we don't build a trust-based relationship with our outside partners by making something that was a win-win, not a win-lose, but a win-win for both sides, that's not sustainable either for in-house counsel or outside counsel. So what I tell them is the sword of Damocles is not only over the heads of our outside lawyers, it's also over them. As inside lawyers, they've got to find a way to add value themselves. And if all they do is pick up the phone, call you guys, ask for a discount, any business executive can do that as well.
Yeah, there was a question here.
Hi, thanks. I was struck by your comment about that lawyers don't have a good sense of what it means to be a good lawyer, and that we look at, where you're employed and things like that. And I was wondering if you think that has a connection to do with the rise in directories, in all these rankings and nominations and things like that.
I think it's been a facet of the profession, I'm sure others can talk to it as well, a facet of the profession for a very long time. The directories are exacerbating it. We had some legal angels, or we call it legal angels, and I try to come up, when a bell rings and an angel gets its wings, or I guess when we do new things, legal angel gets its wings. But in any event, these legal angels talked about where all the money in Silicon Valley is going, and it's going to these B2B type of efforts, this directory approach, rating services that are premised on that. So it's only getting reinforced and getting worse. But the places like Avo, et cetera, I'm sure that's exacerbating the trend.
We had one in the back, and then I'll look to the other side. Go ahead.
Toby, I think you acknowledged that a number of the changes that we're trying to make require investment of non-billable time in order to get there. And Amar, you acknowledged the benefits of some of the developments of partnership, the concept, the limitations of our current partnership structure. Can either of you address any trends or progress that you're seeing in the development of whether it's new compensation systems or other approaches in this country?
I want to make sure I understand that. You're talking about where we're investing our time and money, or how?
Process improvement's a good example where I need to engage lawyers in process improvement, and unless I can pay them by the hour, by awarding them some kind of creditable time or something, it's hard to make progress there. And so that's one example.
Okay.
And so the question is, as you're looking at trends, are you seeing any trends in changes to compensation systems or loosening of investment of that kind of time?
Oh, good question. The trend I am seeing, and this is slow, and one of my sayings, among all my other sayings, is all roads lead to the compensation system. I know personally I have started to get involved in our compensation discussions. I know some colleagues at other firms are getting involved in compensation discussions. And until we, as an industry, can say, let's change that. So the trend is that it's beginning. I think we've got quite a ways to go there. In terms of other investments, my approach, you saw, my 5 things I put up there, is that I think different things are going to appeal to different types of practice and different partners, like project management. So I have been hesitant to make big investments in any one until my customers tell me what they need. But that goes back to, and this would go back to my reputation fear thing, when we change compensation systems that basically recognize all of this and say, lawyer, if you're not profitable, it's going to be reflected in your compensation, then we're going to have lawyers come. In fact, one of my goals is I want lawyers coming and begging me for resources. I don't know what else you'd add.
Yeah, we have an ACC Value Challenge Steering Committee. It's formed of general counsel and others who help launch the effort, and we have a monthly call, and we bring value champions, and we'll come back to that in a second, but we bring value champions onto the calls to chat about what's happening in the industry. And one of the questions, initially, when we first started this initiative, we really didn't want to get into the inner workings of law firms and how you compensate your associates, et cetera. But I'm starting to sense among the general counsel that they're getting frustrated a bit, and they might start talking a little bit more about this, that they're frustrated that there isn't a compensation system that rewards the kinds of things you were talking about at this conference. That it sometimes rewards lockstep behavior, just moving up one year to another, et cetera, et cetera. So that is a concern. The value champions thing, I want to make sure I mention, I have a bunch of law firms in the room, and we want to name you all value champions at some point. 3.5 years ago, our new president, Vita Richardson, launched this new effort where companies and law firms that work together, and it can be one or the other, when they work together, reducing legal spend, improving legal predictability of legal spend, or improving legal outcomes with robust data sets, we will announce them as value champions. We celebrate them. We just celebrated our most recent crop, and I'll be talking about that a little bit at our education session just a few weeks ago. They come to the annual meeting for free. Anyone who's been involved in the ACC annual meeting knows that's a huge, cost savings. You come to the annual meeting, we celebrate you there in front of everybody. We put you in our docket out to our 37,000 members. We put you on sessions about what you did. This is a tremendous opportunity to take what you do and spread it out to the rest of the legal profession. So I hope our next call for nominations will be in November. Hoping to see more of your firms submit nominations.
Okay, this side of the room. Yes.
You talk about changing the compensation structure. You're talking about going to what we're doing in England and Europe. You're talking about putting it in, we can all buy into partnerships, or as a CFO or CEO, you can be a part owner of the business. What the compensation system is going to change the structure? Tell me, what do we do today to fix it?
I'd love to see alternative business structures in the United States. I don't know what the temperature of that in this room is, but we know that state bars, the American Bar Association, tried to get them to move on this a few years ago to no avail. So we're thinking about our own effort on this front. We would love to see a different kind of structure for how law firms are operated and organized.
I would have like two points to make. One is, and you can point at me because I used to work for the Utah Bar, but I was actually on a panel for what's called the National Conference of Bar Presidents in February. And when I was done, I wrote a blog post on our Three Geeks blog, and it was entitled "The Profession is Doomed."
I read that post. It was great.
Because I was sitting there looking out at these bar presidents and executive directors, and they were arguing against change. And I finally raised my hand because no one was asking me any questions. I said, "You people don't get it," and I really laid it out to them. But when I walked away from it, I decided they are not going to do this. We are not going to get the alternative business structures here. We will have 51 different entities fighting over what it looks like. And what shocked me was there was a guy in the back of the room from a state in the South, rhymes with Mississippi. And we were talking about limited licensure legal technicians. And he goes, well, and I've got lawyers who are underemployed. I'm never going to do anything like that until my lawyers are fully employed. And I'm like, whoa. So I don't see that coming from the bar. So what could we do on our side? And this is, I'll preface this with, this is a concept I have. I've actually published it in a book. It is not what, I wouldn't say my firm is doing it, but what I suggest in that, I put it out as a compensation straw man. And I think an effective compensation system has to reward certain behaviors. And what I laid out was a base, and I threw it out like 1,000 hours. to say we expect every partner in the firm to bill and collect on 1,000 hours, not 2,200, just 1,000, because partners do, they're owners and workers and they need to participate. And then I define 3 different ways where they can raise their income, because they'll get a base salary based on the 1,000 hours. And it's your classic finders, minders, and grinders. If you're like a star quarterback, subject matter expert, regulatory or whatever, we'll compensate you because you're really good at that, but you're not driving the business. The quarterback of the New England Patriots, which you're from that area, right? is not in charge of making business decisions. They might get decent compensation.
He's in charge of inflating footballs?
He made a few decisions. But then you have the minders, or those who would be focused on institutional clients of the firm, but I would say profitability has to be key to what you're doing. And the third one is if you're bringing in new business, that's a whole different thing. And so my suggestion for the market is to look to a compensation system that rewards those behaviors instead of the one behavior it rewards now. So
Totally.
I think we can do it within the existing rules.
I don't see how that changes how law is structured and how we provide those services. If you have an alternative thing where people could buy in stock or whatever, how does that, because they're all profitable businesses, they want to be paid money too. So how does that change the perception of practicing law of making money?
You're saying if we did allow external investment? I actually had this conversation with the general counsel of a bank a couple of decades ago. Thank you. And she was arguing against allowing it. And I said, time out. Her name was Cindy. And I said, the banking industry had to raise a whole bunch of capital as an industry to lay out an ATM network. That wouldn't have happened unless they could raise capital, external money, and invest in those things. That I think would be the primary argument to say if we allowed outside investment, all of a sudden there is an impetus, the profit motive, to say we need returns on that money. What the shape of that's why I would say our compensation systems have to reward certain behaviors that would say let's drive some changes around how we make those investments and what we're focused on. Is again, to the question earlier, we are very, very early stage here. And frankly, I don't, my concern, I actually do think the profession is doomed because bars are not going to be able to agree on this. Having been through very, very simple bar association things. In fact, that limited license or legal technician thing, Washington State is doing it. It took them 14 years to do it, and it was against the wishes of the bar. The court made them do it.
I totally agree with all of that. I think that you'll be able to have a more sustainable law firm long-term, would be able to get outside investment. But this is happening right now. We're becoming bystanders in our own profession. If you really look out there and you see all the different companies that are started by non-lawyers that are providing what essentially are legal services. And there's a whole raft, and I don't want to call them out, but there's a number of them that are out there. And I'm a member of the DC Bar. I wouldn't start such a company because I would get disbarred. But all of these folks aren't members of bars. Some of them are former doctors and engineers, et cetera. It's all risk management to them. It's sort of like when a company goes into Russia, you kind of know they're violating the FCPA, right? It's a risk tolerance issue for them. And they look at the bar regulators, and the bar regulators are not enforcing in this context. They're enforcing against legal Zoom and Rocket Lawyer. They're not enforcing when there's a sophisticated client there. And so they're already out there. They're already developing expertise in this market. And so what's going to happen? So we're just going to sit there and watch them do this? Yeah, so you're right. The state bars are a problem. So we're just going to go around them. Our effort is going to go perhaps to the legislatures and to others to explain to them that if they really want to see an orderly market, the state bars are actually a hindrance, an obstacle, not an ally.
There is one thing that might break that dam loose. I don't know if you saw this week. LegalZoom has sued the North Carolina bar, basically on federal trade. They're constraining trade. $10.5 million claim, which I don't think is enough, but it's going to be enough to get the North Carolina bar's attention. And if they succeed, and all the bars I know, because I still have friends in that world, they're concerned. They could basically say, if you're not going to do it, the FTC is going to do it for you.
The unfortunate part, that this was a North Carolina Board of Dental Examiners case from the last Supreme Court term. The unfortunate part, we took a hard look at participating in this case, is that active supervision by a state body can insulate you from antitrust damages. And that state body is the state Supreme Court. We all know in this room the state Supreme Courts don't really supervise the state bars, but they're judges. And I think other judges are going to have a hard time saying that the state Supreme Courts aren't actively supervising.
Well, we thank you for your time. If you have more questions, we'd be happy to answer them the rest of the day. And I recommend that Amar's session later today, you'd probably find a lot of value there. Thank you again for coming.
Thank you.